In the ongoing case, both Ripple and the SEC ultimately concede that Ripple owes no fiduciary duty to XRP holders. As a result, the XRP army is ready to serve its own interests in the matter. There's a lot more to it than that. Do you want to find out more? Then continue viewing this video until the finish. Welcome to the XRP family. Let's help the XRP Hut community develop by liking and subscribing. The U.S. Securities and Exchange Commission has filed an opposition to Ripple's motion to compel it to explain how the Howey test was used in practically all of Ripple's XRP transactions. According to the complaint, the defendants remained until the conclusion of truth discovery. More than 7 weeks after winning the SEC's first interrogatory reply, they informed the SEC that their responses were inadequate. The SEC then supplemented 5 of the issue's responses, gathered and conferred, and directed defendants to determine what specific information they still needed. As required by the Federal Rules of Civil Procedure, the SEC has substantively explained the interrogatories at issue. In turn, the SEC noted that Ripple's case boiled down to their dissatisfaction with the answers they provided. Furthermore, the SEC stated that Ripple delayed filing complaints regarding the SEC's interrogatory responses. This is despite the fact that it attempts to provide further information regarding the requested information. In any case, the SEC provided Ripple with substantive responses to 12 of its requests for admission on the precise points Ripple will undoubtedly use to demonstrate that their required staking requirement was insufficient. The SEC's resistance did not sit well with the community, with many people hoping that the SEC would not express itself. According to the latest developments in the SEC's litigation against Ripple, XRP holders are serving their interests. This suggests that the XRP community has stepped forward to safeguard the altcoin's price from a negative influence. Ripple's holdings remain the largest public holder of XRP, as does litigation against the payments giant. Since December 2020, this has constantly had a negative impact on the price of the native asset XRP. John Deaton, the founder of Crypto Law.us and an outspoken supporter of XRP, believes holders can now take action. In response to Deaton's call to action, the community has granted a class action lawsuit. Following a drop in the total crypto market capitalization caused by a flash crash, the XRP price was reclaimed thanks to an increase in on-chain activity. According to Santiment data, the price of XRP increased by 10% following a minor pullback as address activity increased. Historically, an increase in unique addresses has been followed with a price increase in the short to medium term. Furthermore, positive developments at Ripple support the bullish narrative of XRP. The news of the Japanese financial behemoth's fund is good news for Ripple and may boost the utility of the native asset XRP. Analysts predict that XRP's price movement will be defined by its behavior inside a narrow range, meaning that the altcoin will shortly reach $1.60. In the epic battle between the U.S. Securities and Exchange Commission and Ripple Labs Incorporated over documents, the blockchain company's subjective strong faith in selling more than $1.3 billion in XRP digital tokens proved to be irrelevant. Judge Sarah Netburn of the United States District Court for the District of Columbia ruled on Sunday that Ripple did not violate attorney-client privilege when it presented in March, in response to the SEC's complaint accusing the company of selling unregistered securities, that the SEC failed to provide clear notification if XRP was subject to federal securities rules. According to the judgment, Ripple is not required to give up hundreds of protected documents to the SEC. In a letter briefed to Netburn a few months ago, the commission contested that Ripple's affirmative proper use defense had placed all of the company's legal counsel about XRP. The SEC already has records compiled by Ripple's outside counsel on whether XRP meets the U.S. Supreme Court's security criteria. Ripple gave the papers to the SEC during the SEC's years-long inquiry into XRP sales before the SEC filed its complaint in December. However, the SEC stated in its letter brief to Netburn that it needed to review hundreds of additional legal papers for which Ripple claimed privilege in order to expose the company's fair notice defense. The SEC stated that Ripple was well aware that XRP may be constituted a security, as advised by its counsel in letters shared with investors. The SEC argued that by asserting that it did not get fair notice, the business had began to probe about its state of mind in trading XRP. And, despite the fact that its elegantly crafted answer to the SEC complaint did not directly mention the company's good intentions. They claimed that Ripple did not contest in its affirmative defense that it had relied on the advice of its lawyers, that it had worked in good faith. The company alleged that it was denied due process since the SEC failed to clarify whether the digital tokens are secure for 8 years as the market for XRP grew. According to Ripple, the relevant precedent was not Bilzerian but the Second Circuit's 1996 judgment in Upton v. SEC. In that case, the appeals court emphasized that Upton's fair notice defense was predicated on his contention that the SEC failed to offer fair warning of the banned behavior to market partners, rather than his subjective opinion of his conduct. Ripple said that it's no coincidence that the SEC couldn't find any cases in which courts denied attorney-client privilege to a defendant asserting an Upton-style fair notice claim. Ripple did not raise the defense to call into question its subjective state of mind or the advice of counsel. The SEC's view on whether XRP is a security, rather than Ripple's, is a critical issue in the lawsuit. Previously, the magistrate judge ordered the SEC to submit records revealing its internal deliberations over whether XRP, Bitcoin, and Ether are currencies or securities. Netburn was correct when she stated that her decision is restricted to whether Ripple violated privilege by raising a reasonable notice defense. It was not based on the reason's final worth. The SEC asked U.S. District Judge Annalisa Torres, who is overseeing the case, to rule on that position entirely, stating that it has given the Bitcoin market ample notice through more than 70 enforcement actions against issuers. In its response brief, Ripple stated that the facts are so hotly contested that the defense cannot agree on a move to strike. Ripple General Counsel Stuart Alderete expressed his delight in an email message. The court made it clear that Ripple's defense that the SEC failed to provide fair notice to the market should be directed at the SEC, not Ripple. The SEC is already aware of Ripple's outside legal counsel on XRP, however the two sides disagree on what those letters indicated. They've been revealed in court files but are still under seal. The SEC had informed Ripple that it needed the remaining protected papers for impending depositions of corporate witnesses. Following Netburn's decision, the government appears to be constrained to what it already has. The views expressed here are solely those of the author. For the past 5 years, investors and project developers in the $2 trillion blockchain innovation market have been restricted to an increasingly irritating charade dubbed regulatory clarity by the U.S. Securities and Exchange Commission, SEC. Years of SEC speeches, public pronouncements, meeting records, correspondence, and first-hand experiences from market participants have produced nothing but confusion about the regulations governing digital assets or distributed ledger technology, DLT, initiatives. Another financial disaster is on the way. Other cryptocurrency companies have been lending things to clients who own digital assets, and the United States' only publicly traded exchange sought to do the same. The SEC acknowledged by issuing subpoenas for records and depositions, requesting a list of all their clients who had expressed interest in the product, and eventually issuing a warning of upcoming enforcement action. The United States has enjoyed a fintech boom, but it is not expected to continue. The ongoing clarity charade is enticing fintech innovators and investors from around the world. Through a transparent process, the SEC is meant to create clear, unambiguous rules. Lack of clarity has previously caused a financial crisis, and it has the potential to do so again. One of the most difficult decisions for traders and investors to make is whether or not to invest in XRP. At its current price, it is significantly more affordable than most other cryptocurrencies in the total crypto market. This makes it appealing to many investors, as well as suited for widespread adoption and informational purposes. The benefits it appears to offer, such as transaction speed and minimal fees, would make it appear to be a smart investment with greater potential for institutional backing and advances in the near future. If you want to learn more about XRP, there are 2 more videos on the end screen for you to watch. Please subscribe to our channel and give us a thumbs up. Thank you for viewing. I'll see you in the future video. Please keep in mind that cryptocurrency prices change rapidly, so by the time you see this video, it may have changed to a completely different value. This video's information does not represent investment advice, financial advice, trading advice, or any other type of advice. It would be beneficial if you did not regard any of the content as such. The information in this video is provided solely for educational purposes and should not be construed as financial advice. Do conduct your own due diligence and consult your financial advisor before making any investment decisions.